Welcome to online study of Mohammedan law in India. That is, in this class, let us discuss regarding death bed transaction. What is death bed transaction? If a Mohammedan, while anticipating death in illness, he makes any transaction in respect of his property, then we say that is death bed transaction. In other words, it is called marjul maut. What is marjul maut? Marjul maut means death illness. Marjul maut means maut. Marjul maut means deathbed illness. So a gift made in mortal sickness is so far as regarded as a bequest. So once a gift is made, when a Mohammedan is in sickness, and that sickness is such that he may die, when he makes a gift, that will be treated as a his power, that is like a will. Operate on more than no, so in such case, he cannot make gift of the property exceeding 1/3 of his share unless other heirs consent. But when he makes a gift, when not in illness, he can make gift of his entire property. So this is marjul maut gift. A gift made in mortal sickness is so far as regarded as bequest. It will be treated as if he is making a will. So it cannot operate on more than 1/3 share of that person after the net assets unless the other heirs consent. So what is deathbed gift? What is the difference between deathbed gift and ordinary gift? So far as ordinary gift is concerned, when that is not in deathbed gift, you can make gift of the entire property. But in will, the Mohammedan cannot make will of more than 1/3 of his share unless the other share of the shares or the successors or the other persons, his heirs, other heirs consent. So the deathbed illness is that. What is deathbed illness? Deathbed illness is that it is one which it is highly probable will issue cause his death. The illness is of such a nature that it is probable that it will cause the death. So that is called marjul maut. Otherwise, death illness. Illness is of such a nature that will cause the death. So this is called what constitutes marjul maut. So to constitute marjul maut, the following conditions are necessary. Death illness is that there must be a proximate danger of death. The illness is such that there is possibility of his death. There must be some degree of apprehension of death in the mind of the person. There must be apprehension in the mind of the person that he will die. There must be some external indicia, that is the chief among them being the inability to attend to ordinary avocation. That is, must be external indicia, that is unable to do his day-to-day work and to stand up and make prayer. Then that will be treated as marjul maut, that is death illness. And illness is marjul, when the donor at the time of gift is suffering from a disease, which is the immediate cause of death. So marjul maut means that is a disease, is the person who is making gift is suffering from such a disease. From that disease he is apprehending itself. The disease is of such a nature or character as to induce in the person suffering the belief that death would be that he will die. Then that will be treated as marjul. Second, the illness is such as to incapacitate him from pursuing his ordinary avocation, ordinary work, unable to do his ordinary, is bedridden, unable to stand, make his prayer. The illness after long continuous has taken such a serious turn as to cause an apprehension of death. that is, illness is of a serious nature, which will call apprehension of his death. So this is marjul maut. Marjul maut means deathbed illness. When a Mohammedan under marjul maut makes a gift, that will be treated like a will, that he can make such gifts up to one-third share of his property, but he can do so, but above that, for the consent of other heirs is required. It is also known as deathbed gift. A gift during marjul maut or deathbed gift is essentially a gift. It is therefore subject to all the conditions of validity of. Similarly, all the conditions of validity of gift, that is, there must be a declaration or manifestation of which gift the part of the donor, that the property, gifted property must be accepted by the donee on behalf of the donee. Delivery possession, all the requirements of a valid gift, those are to be satisfied. So a Mohammedan has unlimited power to dispose of property by way of gift, but the law has imposed a restriction on the donor's power to dispose of his property by gift during marjul maut. So what is marjul maut gift and hiba? Ordinary, in the ordinary sense, that is when the Mohammedan is not suffering from any illness, he is not in deathbed illness, he can gift any of his property. But so far as when he makes a gift during his marjul maut, or that in deathbed, he cannot make gift. That is the other conditions like will that is to happen. That is, a deathbed gift when made to a non-heir cannot operate on more than one-third of the testator's estate after payment of funeral expense and debts. When made to an heir is altogether invalid unless the other heir consent. When it is made to a heir, if the other heirs do not consent, that is to be treated as invalid. This is that a gift made by Mohammedan during marjul maut cannot take effect if made in favor of an heir unless the other heir consent thereto after the donor's death. After the donors, the person who was gifted, if he, after his death, if other heirs do not consent, then that gift is void. Marjul maut is a malady which induces in the person suffering from it and apprehension of death, and which eventually results in his death. Marjul maut means apprehension of death, and thereby he dies. That is, this is called marjul maut. Deathbed gift. When a gift is made while in marjul maut, that is in deathbed illness, that is called deathbed illness gift. Deathbed gift. So that is so far as non-heir is concerned, one-third is not exceeding one-third, but if in favor of a heir, similarly that the other heirs must give consent regarding that to that gift after the death of that Mohammedan. So this is called marjul maut. Difference between marjul maut and donatio mortis causa. Donatio mortis causa, what is that is gift? That is donatio mortis causa as embodied in section 191 Indian Succession Act. Differ from the gift made during marjul maut. In that under the former only movable property can from the subject of gift. That is donatio in that under the former, that is gift, that is under the donatio mortis causa. Only movable property can form the subject matter of gift. But in case of this marjul maut gift, difference marjul maut, it may be movable property, it may be any property, movable. Further, in case of donatio mortis causa, no limitation are placed. Donatio mortis causa, no limitation are placed, either as regard the person to whom the or to what extent property is to be given. But under bequest cannot operate of more than one-third of the testator unless with the consent of the other heirs. In the case of donatio mortis causa, if the donor recovers from the sickness, donatio mortis causa, if the donor recovers from the sickness, the gift entirely fails. But under Mohammedan law, a gift made during illness would be valid to the whole extent if the donor subsequently recovers. Similarly, in case of deathbed transaction, a Mohammedan may acknowledge the debt. A Muslim may acknowledge the debt during marjul maut. During his deathbed illness, he may acknowledge the debt made by him, but it is not free from suspicion. And as such, when the only proof of debt is deathbed acknowledgement, The payment of the particular debt is deferred as against the debts acknowledged by the deceased while he was in health. Because this, when in deathbed, there may be some suspicion that again those proved by other evidence also required. So similarly, the release of debt during mortal mouth is valid only to the extent of the bequeathable one third. So release of dower debt, similarly, the gift of a dower debt by a sick woman when the probability is that the death would ensue would not be valid except with the assent of the heirs. That is again provision. Work upon deathbed, all are deathbed transaction, mortal mouth. So a workup made in death illness is like a gift made without consideration and is valid only to the extent of the legal third, that is one third unless the heirs consent for it. Similarly, effect on sale, the doctrine of mortal mouth holds good in transaction or transfers which are without consideration. According to sale or other transaction for consideration are beyond the provision. When consideration is made, so that will not be invalid, that is, this mortal mouth will not be applicable. Gift in lieu of dower. A gift in lieu of dower is for all practical purpose regarded as a shell, and therefore even a deathbed gift in lieu of dower would not be subject to the limitation. When a gift is made in lieu of dower, that will be treated as a shell. So in such case, this rule as one third share up to one third share, the consent of other heirs, that is not required. So marriage contracted on deathbed. Sometimes a Mohammedan, when marriage makes a contract of marriage during deathbed, what will be the consequence? According to the Sharia ul Islam, a marriage contracted by a sick person is dependent on consumption, so that if he dies of the illness without consumption, the contract is void. Without consumption of the marriage, if a Mohammedan has that is contracted a marriage but without consumption, he dies, that marriage is void. And the woman has no right to dower or succession. In such case, the woman is not entitled to dower or succession. If, however, the party in health dies during the lifetime of the one who is ill, the marriage is valid. Suppose the wife dies during the lifetime of that person who has made a marriage during that is mortal mouth, then such marriage is void. And opening mutual right of inheritance. There is, however, some diversity of opinion with regard to husband's right of inheritance when he is suffering from death illness, and the wife who is in health predeceased. That is, in case of predeceased, the wife predeceases. Even the marriage is not consumed, then the wife is entitled for that will go to his successors. This is in nutshell. What is deathbed transaction? It is called as what? Martul mouth. Marjul mouth. Marjul mouth means when the person is making any, Mohammedan is making any transaction that is in death illness. So you are now you are clear. Then the other chapter, that is a inheritance of property by a Mohammedan. So first, inheritance by a Mohammedan of his property, when by will and without a will. So when a Mohammedan has made a will, and that we have already discussed what is wasiyat, to what extent there will be a will. So when succession, that is to be administrated, how that will be administered, how that succession will take place. The Muslim law of succession, which has been derived from succession from the Quran or in traditions, as well as from such of the pre-Islamic customs, are approved by the Prophet. This succession is approved. So this is Muslim. What it says? Application of the property of a deceased Muslim. Then after his death, if there is a will, which property will be given, will be succeeded by the legatee, in whose favor such a will is there. The estate of a deceased Muslim is to, what is the estate? What is the estate of the deceased applied? According to the Indian Succession Act. So according to the Indian Succession Act, the left, when there is a will, that will be applied on following the principles as per the Indian Succession Act. That is, in following order. First, in the first order, first payment of his funeral expense. When there is a will, First, from the property in respect of which there is a will, the funeral expenses is to be paid from that property. Second, expenses of obtaining probate, letter of administration or succession certificate. What expense that was incurred for obtaining a probate certificate, succession certificate, that is also to be deducted from that property. That expense will be made from that property. Property which has been in respect to be, there is a will. Third is that wages due for services rendered to the deceased within 3 months next preceding his death. Within 3 months prior to the death of the testator, whatever wages was due to the servant, that is also to be deducted. Third is legacy is not exceeding 1/3 of what remains after payment of these items. What are those? Funeral expense, expense obtained in probate certificate, then wages, that is to be excluded. Thereafter, then the third is then the all debts of the deceased according to our respective probability. Debts are also to be paid for. Thereafter, if any property is left, then that will be succeeded by the legacy, not exceeding 1/3 and of remains after payment of the aforesaid, as I told you, all the expenses. Legacy is not exceeding 1/3. What remains after payment? The residue to the distribution among the according to the heir. After 1/3 is gone, then the residue property will be distributed among the other heirs of the Muhammadan. So what is that? Then who will represent a deceased Muslim in obtaining a probate certificate or execute the will? First, executor or administrator. Second, or in the absence, heirs or derivative executors. First, execution of executor or administrator. What do you mean? You should understand who is an executor or administrator. Executor means a person to whom the execution of the last will of a deceased person is by the testator's appointment codified in the document itself, in the will itself. If somebody has been nominated as executor to execute the will, he will be treated as executor. So administrator means a person appointed. Suppose no executor is there. Administrator means a person appointed by competent authority or by the court to administer the estate of the deceased. He is called administrator. You should understand, because sometimes it creates a what is the difference between executor and administrator. Executor means if a person who has been named will to execute the will, he is called executor. When there is no executor, if the court appoints somebody to administer the estate or the property of the deceased person, in respect of the property which there is a will, he is called administrators. Heirs in defaulted an executor or administrator. Suppose heirs, third is heirs. Suppose there is no executor, then no administrator. Then the heirs can represent the Muhammadan. So in such case, when there is no executor, administrator appointed, the whole estate of the deceased devolves upon the time of decease upon his heirs. All the heirs upon which whole estate of the Muhammadan devolves, that is on the proportion of their respective right. An heir can also Muslim represent the Muslim. Derivative executor. That is, the executor of a deceased Muslim may validly and rightfully appoint a successor to him. An executor who has been named, he may validly appoint another person to execute the will. He is called derivative executor. So how the property will devolve? The devolution is not suspended by reason merely of debts being due. As because there is debt, the devolution is not suspended. The very moment the deceased dies, the property devolves on the heirs as per their respective share as tenant income. Each heir is under the personal law liable to satisfy the debt of the deceased only if the extent of the share of the proportionate to his share in the estate. That is sometimes sued by creditor. If the estate is represented by an executor or administrator, a suit by creditor of deceased should be instituted against them. Suppose creditor is entitled for some money, some debt, then if they issue already there is a suit, estate is represented by an executor or administrator, then the creditor may file a suit against them for recovery of the debt amount due to the deceased Muhammadan. Suit by creditor against heirs. If there is no executor or administrator, suppose there is no executor or administrator, this creditor may proceed against the heirs of the deceased, and where the estate of the deceased has not been distributed within the heirs, when the deceased again the estate, the property of the deceased have not been distributed between the heirs, the creditor can execute the decree against the property as a whole without regard to the extent of the liability of each of the heirs. Recovery of debt due to decease. As one heir cannot give valid discharge of the debt due to the decease, no court can pass a decree against a debtor of a deceased Muslim for payment of his debt unless the claimant produces a probate or letter of administration or a succession certificate before passing of the decree and not necessary at the time of the institution of the suit. So you say this is some idea how it is given to you that how a property of a Mohammedan in respect to which there is a will that is to be, who will bring the suit and how that is to be administered. Then the other chapter is inheritance. There is no will. Then how the property will devolve? You know, in case of this Hindu law, that is, we have a Hindu Succession Act. But in so far as Mohammedan law is concerned, there is no codified law governing the succession. So still, this uncodified law, Quranic principle is applicable. So greater part of Mohammedan law of inheritance is founded upon the Quran. So how property will be inherited by the heirs of a Mohammedan, that is governed by Quran. Quran did not sweep away the existing laws of succession. Quran also recognizes, according to that, existing law of succession, but made a great number of amendments based on new common principles. According to Quran is followed. So that is, with some modification, that is followed. Then again you say, what is heritable property? What is heritable property? In case of will, we pay what property? That means first funeral expenses is deducted, then there is any debt is to be deducted, expense obtaining probate, that is to be deducted, any wages of a servant prior to his 3 months, that is to be excluded. Similarly, which property is to be herited? What is heritable property? You should know. What is left after deducting the following, that is funeral expense, expense obtaining probate and this administration from the court, wages for personal service of the deceased for 3 months, debts, legacy subject to the limit of testamentary power. If these properties are excluded, if other properties are there, in respect of that, there will be succession. That will be inherited by the successors. So, in case of this Hindu law, what is the difference then? In Muslim law, property is one and there is no distinction between ancestral and self-acquired property. But in Hindu law, the property, there are two types of property. One is ancestral property and the other is the self-acquired property. But such a difference is not there in Mohammedan law. Second, there is no such this concept of joint family in Mohammedan law. In Hindu law, there is a joint family. The right of an heir for the first time comes into existence only after the death of a Mohammedan. But in case of Hindu law, co-personal gets a right in the property by birth. In Muslim law, does not recognize space succession, chance of succession, that is also there. So now, applicable of this order, the main principles of succession are as follows. First, rule of representation. rule of exclusion, rule of primogeniture, rule of vested inheritance, rule of space succession. So in the inheritance of the property of a Mohammedan, the following rules are that is applicable. So this the main principle of succession, the succession of a Mohammedan of the property that is governed by rule of representation, rule of exclusion, rule of primogeniture, rule of vested inheritance, rule of space. What is rule of representation? Rule of representation means suppose representation has more than one meaning. It may be applied for the purpose of deciding what is rule of representation. It is to be applied first, deciding what persons are entitled to inherit the property. Rule of representation means first decided who is proper, who person, who are the persons who are entitled to inherit the property and quantum, to what extent he is entitled to inherit. This is called rule of representation. Rule of representation first in succession. The rule of representation means who is proper, what persons are entitled to inherit the property and to what extent or to what quantum of share he is entitled. You know per strip and per capita. What is per strip? Per strip means in branch wise. That is called per strip. Per capita, per head. The division of an estate among heirs belonging to different may be referring to different branches. Maybe according to different stock or branch to which different that is sex here, or it may be according to the individual heirs or claimants without regard to the representation of the branch. When a particular share, a particular quantum is given to a particular branch, we say that is called per strip. When per head, that is called per capita. So first the rule of representation. You should understand that for inheritance of the Mohammedan property, after if there is no will, first there will be deduction, that is funeral expenses to be deducted, expenses for if then will for that is to be deducted, wages due to a servant prior to 3 months of his death, that is to be excluded. Then testamentary disposition is that is to be excluded. If any other property is thereafter property remains, then that will be succeeded by the, so every Mohammedan. So first that is rule of representation. Only rule of representation means the first it to determine which heir is entitled to succeed the property and to what extent he is entitled. If there also the per capita and per strip principle will be applicable. Then second is rule of exclusion. What is rule of exclusion? Some persons will be excluded to inherit the property of a Mohammedan. Say for example, a person has caused homicide. One of the heirs has caused homicide. Then he is to be excluded. So that is second principle is what is the rule of exclusion. Every person, including a child in the womb, provided is born, is entitled to inherit unless there is a specific rule of exclusion. First, there is a specific rule for excluding a particular heir, then he will be excluded. According to this rule, that is called rule of exclusion. So it is to be determined to this rule persons through heirs are excluded. Some persons are excluded from inheritance. First is homicide. Under Sunni law, a person who causes the death of a person is not entitled to inherit his property. So no matter whether the death was caused intentionally or by accidentally. But under Shia law, if accidental death will not inherit, we exclude that person from inheritance. Second, illegitimacy. They need to be excluded. So illegitimacy, under Sunni law, a illegitimate child is not entitled to inherit only is entitled to inherit the property of his mother, not the father, but not his father. But under Shia law, an illegitimate child is disqualified to inherit both his mother and father's property. So this is the second rule is rule of exclusion. That is to be. Who are to be excluded? On the ground of slavery, somebody was being excluded. Now it is abolished. that is abolition of slavery act. So difference of religion also on the ground of apostasy. The Caste Disabilities Act, Removal Act 1850, does away with India with the exclusion from inheritance from a deceased Muslim on the ground of mere difference of religion. Similar difference of allegiance, that is not applicable. Estoppel in succession, a person, it is very important, a person who first denies the relation with the propositus means whose property is to be succeeded, cannot be allowed subsequently to turn his back and claim inheritance when succession opens. So this is called, second rule is rule of exclusion. Doctrine of exclusion, the doctrine consists of a set of three rules which governs inheritance. A person who is related to the propositor to another is excluded by the person. If somebody is related to a Mohammedan to another, and if that person is present, then the other persons will be excluded. Second is that a person who is related to the propositor to another is excluded by the presence of the other. If that person is present, suppose a Mohammedan has a son, he has grandson. After his death, the son will get the property, no grandson. Similarly, within limits of each class of the heir, as heir near in blood exclude the more remote. You should understand, it is very important. Suppose a Mohammedan dies leaving his three sons and two grandsons, that is from the predeceased son. In such case, the grandsons, because they are in more remote in relation, they will be excluded. Only the sons will. This is the instance, that is exclusion. What is that? When that is with the limits of, that is a person who is related to the propositor to another is excluded by the presence of the other. Second, with the limits of each class of heirs, an heir, suppose a class of heirs, an heir near in blood exclude the more remote. A person excluded by exclude others. So exclusion of daughter right of inheritance under Muslim law, the daughters are given the right of succession. However, this rule is not absolute. Under the customary law, there is some customary law. Daughters are also included, that is in Bombay, that is inheritance under Watan Act 1860. Muslim daughters were excluded from the right of inheritance. Then third is rule of primogeniture. Rule of primogeniture means the eldest son will get the entire property. This is not applicable. So, where a person has several sons, what is rule of primogeniture? If a person has several sons, the eldest son has this preferential claim over the estate of the deceased father. Generally, this is called rule of primogeniture. So, this is not recognized by Mohammedan law in India. That is not recognized. But the Shia, however, recognizes the exclusive right of the eldest son of such articles of the father. But under the Shia law, the eldest son is entitled such articles, that is wearing apparels, Qurans, that is Quran, ring, sword, arm. Because in this case, according to Shia law, the rule of primogeniture will be applicable. Other sons are not entitled for that. But such a rule is not applicable so far as a Sunni Muslim is concerned. Rule of vested inheritance, it is established rule of Muslim law that property never remains in a state of abeyance. So that is rule of vested inheritance means very moment a Mohammedan dies, all his property vests with his successors, who is entitled for that. Property never remains in state of abeyance, but on death of this the property passes to his various heirs. The moment the person dies, his last breath, his property vests in his heirs, though the actual distribution has not taken place. This is called rule of vested inheritance. The rule of space succession, chance succession, where the rule of vested inheritance is applicable after the death of the propositors. Propositor means whose property you say, the rule of space succession applies before this. The rule of chance of succession applies before this. Now you should know, in this there is a who are entitled to inherit. First, there are three types of persons who are entitled to inherit according to Sunni law. First is Quranic heir, They are called sharers. Second is residuaries. Third is distant kindred. Three types of heir. Quranic heir, that is called sharers. According to Quran, their share is determined. They are entitled. That is called sharers. After them, if after a particular share is given to them, if the property is left, then that will go to the residuaries. Who are residuaries? There is a list. Third, if there is not there is a distant kindred. But according to Shia law, first heirs by consanguinity and heirs by special case. In case of Sunni law, three categories of persons are entitled to inherit the property. There are sharers, residuaries, and distant kindred. But so under the Shia law, first heirs by consanguinity and heirs by special case. Heirs by consanguinity, what is that? Parents, first group 1, group 2, group 3. First is parents, children and others. They are in first category, that heir by consanguinity. Group 2, grandparents, householder, householder. Group 3, paternal uncle and aunts, householder. These are three categories of person. They are entitled to succeed the property of a Mohammedan according to Shia law. So this is, this is sharers. You should know sharers, residuaries, and distant kindred. Who is a sharer? Sharer of a Quran, it has been mentioned in the Quran. Who are these sharers? The legal heirs of this class is otherwise known as class 1 heirs. Sharers or the Quranic heirs, they are to be treated as class 1 heirs. Who are the class 1? Who are the Quranic heirs of the profession? What is the respective share that is to be given? Whether such heir is excluded, then 32, whether such heir is excluded because of the rule, whether he is a murderer, whether he is a other illegitimate child, all these things. Third, where such heir is excluded. Fourth is that any other fact which may affect the inheritance. On the basis of these facts, this property will be distributed. The inheritance property is distributed first all among his heirs, among his sharers. First, among the sharers, determined share is given. Thereafter, if the property is left, that will go to residuary. If no residuary, then their property will come back to the sharers. This is a rule that is called rule of return. On the basis of these facts, the heritable property is distributed first of all among the sharers. These are called Quranic heirs. The sharers, their respective share and the condition under which they inherit is given. That is, how much the sharer is get, that list is there. Suppose he is a husband, is a Quranic heir. Husband gets half if there is no child. Suppose a Muhammadan woman dies. If the husband is alive, he gets half. So if the children are there, then the husband gets 1/4. That is a Quranic heir. Suppose a widow gets 1/4 if there is no child. If there is child, 1/8. If more than one widow, then each of that will be taken, divided among them. If more than one widow, all the widows will get equal share from that 1/8 or 1/4 share, as the case may be. Father without child son is treated as a residuary. Suppose if a child is not there, if the person has no son, only father is there, he will be treated as residuary and cease to be a Quranic heir. In such case, he will be cease to be a Quranic heir. Father together with it, suppose child is there, father is there, then the father will be treated as a Quranic heir. So in such case, that means child of son gets only 1/6 heir. Suppose children, if X died, he has sons and father, then the father will get to 1/6 heir. Suppose he has no child, then the father will cease to be a Quranic heir. True grandfather also. True grandfather is entitled, is inherit only in the absence of father. If the father is not there, then the true grandfather is entitled to inherit the property as a Quranic heir. But if the father is alive, he will not get any share. Mother similarly. So the share of mother is one third. In the absence of a child or child son, two full sisters or sisters, two full sisters or two full brothers, then you will get one third. One brother plus one sister, whether full, consanguine or other. If sisters or brothers are not there, then our child is not there, the mother is entitled for one third share. So if the sister and mothers are there, then the mother will get 1/6 share. So similarly, this is Quranic heir. True grandfather. The true grandfather inherits only where she is not excluded by the presence of any of the relations given below. That is a maternal grandmother, that is, if not excluded, the share of the true grandmother is 1/6. Now, daughter, the share of one daughter is half. If there are two or more daughters, the share 2/3 to be divided equally among them. So this is in nutshell what will be the Quranic heir. What is their particular share that is determined, that is fixed. If any property is there, that will go to residuary. If there is no residuary, then the same will be returned to the sharers, Quranic heirs, and that will be distributed among this according to their respective share entitled for which he is entitled. So this is in nutshell. This is a very complicated matter, but you should have some bare idea. This is in nutshell regarding inheritance. On Shia law, there is some slight difference. We can also go through it. Because heirs by consanguinity in Shia law, what is that? This is three types of heir by there are only two types. Heirs by specialty. Heir by consanguinity is group 1, group 2, group 3. That is parents, children. Group 2, grandparents, householder, parental. That is heir by special cases, means this wife, etc. So this is in nutshell we covered the inheritance of. You go through it now. By now, you have some fair idea about the Mohammedan law, because our lecture is not exhaustive. Anyhow, you got some idea regarding the inheritance and what is deathbed illness transaction. Thank you.